Please subscribe to the channel to watch the latest videos.
Trump seethes at gag order in federal case while his campaign relishes it. The former president took advantage of a temporary pause in the restriction to resume attacking special counsel Jack Smith. After a week of privately and publicly fuming at a gag order imposed by a judge in the federal case charging him in attempts to overturn the 2020 election, Donald Trump received a temporary reprieve late Friday. Judge Tanya S. Chutkan agreed to temporarily lift the gag order that had restricted Trump's public statements about special counsel Jack Smith, his team and witnesses, while she considered a motion from Trump's lawyers to suspend it entirely while they appeal. Within 48 hours, Trump issued a new broadside attacking the prosecutor, Trump's first since the gag had been imposed. On Sunday, he took to his social network Truth Social to attack Smith in the exact terms that the order had prohibited, calling him deranged Jack Smith. The sequence illustrated the careful dance Trump had engaged in since Chutkan issued her order. He had refrained from immediately and flagrantly violating the gag order while it was in place, even as he railed against it and continued attacking judges and making a host of other comments that, while not technical violations, most defense attorneys would advise against. Trump was personally furious about the gag order, according to advisors who spoke on the condition of anonymity to relate private discussions. At the same time, advisors said Trump's campaign sees political upsides to the gag order, similar to how the indictments helped propel Trump to a commanding polling lead in the Republican primary. Trump's campaign has been aggressively fundraising off the gag order. Though it declined to specify how much it raised, Trump's campaign sent out more than 36 pitches that mentioned the phrase in the last month. Anything that turns up the temperature and becomes controversial is where the online fundraising comes from, said Brad Parscale, a former Trump campaign manager who now works in online fundraising. It's a lot easier to catch fish in a hot lake than a cold lake. All these stories heat up the lake. As Trump racked up criminal charges over the summer, his campaign message increasingly focused on fighting the prosecutions that he claims are politicized. In doing so, Trump has worked to position himself alongside his supporters, with one fundraising message last week calling the gag order against him an attempt to gag American people and cancel out your vote. "We couldn't script this any better from a political standpoint," one advisor said. "He does best as the victim who is being treated unfairly." In a statement, Trump campaign spokesman Stephen Chung said the former president is a truth teller and speaks truth to power. He has every right to defend himself from these unlawful witch hunts by the Biden Department of Justice and prosecutors who are weaponizing the justice system in an unprecedented attempt to interfere in the 2024 election, he said. Trump gave 2 campaign speeches on the day the order was issued, and appeared again Monday in New Hampshire without unambiguously violating the restrictions. Still, if the gag order is reimposed, advisors expect Trump to break it at some point, betting that the judges won't punish him with jail time. "What are they really going to do to him?" one ally said. The campaign's confidence that the gag order will improve Trump's political standing, and its bet that Chutkan would never dare impose a harsh penalty on a leading Republican candidate for president, helps illustrate the difficult questions in the case as Chutkan weighs to reinstitute or even expand her order. In order to safeguard the integrity of these proceedings, it is necessary to impose certain restrictions on public statements by interested parties, Chutkan wrote in her order imposing the gag. On Friday, Trump was fined $5,000 for leaving on his campaign website a social media post disparaging a court staffer in his ongoing New York civil fraud trial, in violation of a gag order in that case. That order applies only to court staff, it does not cover the judge or the state attorney general who brought the case, and Trump has continued to criticize them. During a campaign stop in Concord, New Hampshire, on Monday, Trump repeated his claim, without evidence, that the indictments originated with President Biden and threatened to retaliate if he returns to power. "These people are dirty players and they go after the political opponents," he said while filing his paperwork to appear on New Hampshire's first-in-the-nation primary ballot. "And it's a two-way street now. It can happen the other way too. We have a judge that's out of control," Trump said Monday during a campaign speech in Derry, New Hampshire, "and he's totally afraid of Peekaboo James," he added, using a derogatory nickname for New York Attorney General Letitia James. "I don't mind being Nelson Mandela," he said elsewhere in the speech, referring to the South African anti-apartheid leader who spent more than 27 years in prison, "because I'm doing it for a reason." Trump has also come close to attacking Chutkan, who like Judge Arthur Engoron, did not include herself in her gag order. "The judge doesn't like me too much," he said in Iowa last week. "Her whole life is not liking me." Trump has a long history of undermining the independence of the judiciary. In 2016, he suggested the judge overseeing the class action lawsuit against his for-profit Trump University was biased because of his Mexican ancestry. In 2018, he attacked a ruling against a Trump administration asylum policy as coming from an Obama judge, leading to a rare reproach from Chief Justice John G. Roberts Jr. There have been some discussions among Trump allies of whether the super PAC or other surrogates could step up to mount attacks that Trump himself could be barred from making, should the order remain in place as the campaign proceeds. But Chutkan's order is narrow. She specified that it does not prevent Trump from calling his prosecution political or from criticizing President Biden or the Justice Department, leaving Trump room to run in his daily and campaign trail rhetoric. Trump's Sunday post calling Smith deranged, however, would clearly have run afoul of Chutkan's order had it still been in effect. "I cannot imagine any other criminal case in which a defendant is permitted to call the prosecutor deranged or a thug, and I will not permit it here simply because the defendant is running a political campaign," the judge said at the October 16 hearing when she initially imposed the gag order. That post and others from Trump are likely to appear in future court filings from Smith's team, which has been closely monitoring Trump's inflammatory comments to argue that they could taint witnesses or jurors. Chutkan has ordered Smith's team to answer Trump's challenge to the gag order by Wednesday. Trump's lawyers then have until Saturday to respond. A spokesman for Smith declined to comment beyond the court filings in the case. In the same post, Trump also attacked a potential witness in Smith's other case against Trump, which would not be covered by Chutkan's gag order. Australian billionaire Anthony Pratt has testified to prosecutors and is on the list as a potential witness in Smith's case accusing Trump of mishandling of classified documents after leaving the White House, a person familiar with the matter said. Trump allegedly told Pratt about the capabilities of U.S. submarines. In response to a New York Times article about Pratt this weekend, Trump called him a red-headed weirdo. Another post by Trump over the weekend targeted a potential witness in the January 6 case, attorney Sidney Powell, who pleaded guilty in a separate case in Georgia charging her, Trump and 17 others with trying to overturn the 2020 presidential election results in that state. The Washington Post has reported that Powell is one of 6 people cited as an unindicted co-conspirator in the case. "Ms. Powell was not my attorney, and never was," Trump wrote of Powell, who participated in a news conference on behalf of Trump and his campaign and attended a White House meeting in December 2020 about contesting the election results. But he also seemed to praise her for fighting to overturn the 2020 presidential election. "It helps us long term," another advisor said of the gag order, "but it doesn't mean he's not mad about it." Devlin Barrett contributed reporting. Trump files new challenges to federal election obstruction case in D.C. The former president seeks dismissal of the indictment on constitutional and statutory grounds, claiming his actions were protected by the First Amendment. Former President Donald Trump launched a multi-pronged legal attack late Monday on his federal prosecution for allegedly subverting the results of the 2020 election, saying his actions were protected by the First Amendment as political speech, and arguing that he cannot be tried in criminal court for attempting to block Joe Biden's victory because he was already impeached by the House but acquitted by the Senate. In court filings that landed minutes before a midnight deadline, lawyers for Trump claimed he was a victim of political persecution by the Biden administration. They called the charges against Trump legally defective and vague, and said the indictment should not link him to the violence of the January 6, 2021, attack on the U.S. Capitol because he is not charged with inciting that riot. Because the government has not charged President Trump with responsibility for the actions at the Capitol on January 6, 2021, allegations related to these actions are not relevant and are prejudicial and inflammatory. Therefore, the court should strike these allegations from the indictment, wrote defense attorneys Todd Blanche, John Lauro, Emile Bove and Gregory Singer. The indictment must be dismissed because it seeks to criminalize core political speech and advocacy that lies at the heart of the First Amendment, they wrote. Trump is scheduled to face trial in federal court in Washington in March after pleading not guilty to an August 1 indictment accusing him of a criminal conspiracy to remain in power, obstruct Congress's lawful certification of Biden's victory and deprive Americans of their civil right to have their votes counted. The case is one of 4 felony prosecutions of Trump charged this year, including a state trial in Georgia that involves similar allegations of trying to obstruct the state's election results, a federal indictment in Florida over Trump's alleged retention and mishandling of classified documents and obstruction after leaving the White House, and a New York State business fraud prosecution accusing Trump of covering up a hush money payment made during the 2016 election campaign. While aspects of the former president's case raise historic and unprecedented legal questions, the motions filed late Monday are fairly typical for criminal defendants trying to challenge the legal sufficiency of the charges against them. Trump's claims of selective and defective prosecution have also been raised unsuccessfully over the past 2+ years by defendants charged in connection with the Capitol riot, in which angry Trump supporters, encouraged by Trump to go to the Capitol after a rally near the White House, injured scores of police officers, led to multiple deaths and forced the evacuation of Congress as lawmakers met to formally certify the 2020 election results. Prosecutors led by Special Counsel Jack Smith will have the opportunity to respond to Trump's motions in coming weeks, both in writing and in oral arguments. Trump's latest legal filings exceeded 100 pages and substantially completed his pretrial motions to pare back or end his case on legal grounds before going to trial. Earlier this month, Trump made his central argument for dismissing the case, claiming that his actions while president are absolutely immune from criminal prosecution. Prosecutors responded that U.S. District Judge Tanya S. Chutkan should reject that argument because it would put presidents above the law and invite lawless measures by presidents to corruptly hold on to power. Trump has more time to seek permission to issue subpoenas or otherwise seek evidence from third parties or the government, and litigation over a limited amount of classified evidence in the trial is in the early stages. Other fights over admissible evidence, testimony, jury selection and instructions would unfold closer to the March 4 trial date. In Monday night's motions, Trump argued that Congress's second failed impeachment effort, in the final days of his presidency, after the Capitol riot, was the proper venue to decide his guilt or innocence regarding his election-related activities. His legal team also maintained that he had acted within the bounds of the presidency when seeking to overturn the 2020 results. The Constitution states that a president impeached and removed from office may be subsequently charged by indictment, trial, judgment and punishment, language that Trump's attorneys argued presupposes that a president who is not convicted may not be subject to criminal prosecution. They added, the Constitution's plain text, structural principles of separation of powers, our history and tradition, and principles of double jeopardy bar the executive branch from seeking to recharge and retry a president who has already been impeached and acquitted in a trial before the U.S. Senate. Prosecutors have previously said that Trump argued the opposite during his impeachment trial, that he could be prosecuted later if the Senate acquitted him, an interpretation that prosecutors have agreed with. Smith's team has argued that the clause was meant to limit Congress's power to remove and disqualify presidents from office, not to preclude the prosecution of those who escaped removal. In a separate filing late Monday, Trump's legal team argued that even if the allegations laid out in the indictment were true, the government did not sufficiently explain how the former president broke the laws he is accused of violating. For example, the defense attorney said that while prosecutors charged Trump with conspiracy to defraud the country, they did not show that his intent was deceitful, an intent that his lawyers said should be necessary to charge him with the crime. The indictment alleges that Trump propagated a flood of false claims about purported voter fraud in the 2020 election and then used deceit and lies to try to get state, local, and federal officials to change the results, resulting in the assault on the Capitol. These claims were false, and the defendant knew that they were false, the indictment states. In fact, the defendant was notified repeatedly that his claims were untrue, often by the people on whom he relied for candid advice on important matters, and who were best positioned to know the facts, and he deliberately disregarded the truth. But the Trump team argued Monday night that the president was not in a position to deceive anyone about whether the election was fraudulent. The lawyers said the case shouldn't be allowed to go to trial and urged Chutkan to dismiss his indictment on statutory grounds. Virtually every American, including the cited public officials, had similar access to much of the same information, including a mountain of publicly reported facts and opinions, which were the subject of wall-to-wall media coverage throughout the post-election period and beyond, the filing reads. To assert that President Trump, as one voice among countless millions, was somehow capable of unilaterally tricking or deceiving these individuals, who include some of the most informed politicians on the planet, simply by advocating his opinions on this contentious issue, is beyond absurd. Trump pledges to turn away those who don't like our religion. Donald Trump is not understood to be a particularly religious person. When he launched his candidacy for the 2016 Republican nomination, he would insist that the Bible was his favorite book, edging out The Art of the Deal, although he was unable to identify a favorite passage or, at times, demonstrate much familiarity with it. As president, he rarely went to church, one exception being when, on June 1, 2020, he strode across a newly cleared Lafayette Square to pose outside St. John's Episcopal Church holding a Bible. This is most obviously how Trump's life intersects with religion. He understands that it is a motivation for Americans, particularly Americans who are inclined to support him politically. During a speech in Iowa in January 2016, he lamented that Christianity is under tremendous siege and pledged to be the religious rights champion in office. Which, for the most part, he very much was. There was a flip side to this, too. It wasn't just that Christians were imperiled, it was that people of other religions were inherently dangerous. He leveraged the existence of the Islamic State and terrorist attacks in France and San Bernardino, California, to cast Muslim immigrants as dangerous. In December 2015, he proposed a ban on Muslim migrants. It was typical of the moment, sparking a huge outcry, including from his eventual vice presidential pick, and seeming as though he'd crossed an uncrossable line. But the Republican electorate drew no such line, and Trump, as president, tried to figure out how to make his promise a reality. By now, there is no surprise inherent when Trump and other candidates for the 2024 Republican nomination paint non-Christians with a broad, defamatory brush. For example, Florida Governor Ron DeSantis, Republican, argued that not all refugees from the Gaza Strip support Hamas, the group that launched terrorist raids into Israel this month, but they are all anti-Semitic. None of them believe in Israel's right to exist. This is not true. Trump, speaking in New Hampshire on Monday evening, went further, as he is wont to do. On day one, I will immediately restore and expand the Trump travel ban, he pledged to the cheering crowd. He interrupted his prepared remarks for a riff about how his opponents tried to stop his ban in the courts, which they did successfully to an extent. Then he continued, he would also halt all of the refugee settlements to the United States. They want to come and they want to bring, the same people that are shooting rockets at Israel, they want to come into the United States, Trump said. I don't think a lot of good things are going to happen. This, too, is not true, as Nikki Haley, a former U.S. ambassador to the United Nations, said in response to DeSantis's comments, American immigration policy includes recognition that you can separate civilians from terrorists. Then Trump again expanded his rhetoric. I will implement strong ideological screening of all immigrants, he said, reading from the teleprompter. If you hate America, if you want to abolish Israel, he continued, apparently ad-libbing, if you don't like our religion, which a lot of them don't, if you sympathize with the jihadists, then we don't want you in our country and you are not getting in. Right? The crowd cheered enthusiastically. Trump vamped, we don't want you. Get out of here. You're fired. This is not sophisticated political rhetoric, quite the opposite. It's demagoguery. But it is also revealing. After all, what is our religion in this nation built by people seeking freedom of religious expression? We all know the answer, but let's explore the question as if we don't know. The Public Religion Research Institute's annual assessment of American religious identity shows that about 2/3 of Americans are Christian. About a quarter are religiously unaffiliated, most of them not religious at all. Religious identity, and particularly Christian religious identity, is more common among Republicans. But that religiosity has slipped since 2006. Then, about 94% of Republicans were Christian. Now, about 85% are. The percentage of Republicans who are religiously unaffiliated more than doubled over that time. Younger Americans are less religious than older Americans, contributing to the sense, exploited by Trump, that the country is moving away from the traditions in which older Americans grew up. But most young Americans still are Christian, This is all Trump is getting at. Our religion, the religion of those in the room at his event, is right-wing, often evangelical Christianity. In 2020, the density of white Christians in a county was a very good indicator of whom voters in the county supported. But let's take this one step further. Is our religion simply right-wing Protestantism? Are Catholics included under Trump's religious umbrella? Where is the line drawn? There were fewer than 60,000 immigrants from Palestinian territories living in the United States in 2020, according to data presented by the Migration Policy Institute. By contrast, there were 2.7 million immigrants from India, where 80% of the population is Hindu. Will a second Trump administration turn away immigrants from the world's most populous country as well? What about Eastern Orthodox Christians from Ukraine? Parsing Trump's comments is excessive, of course, as stipulated, we know what he means. He means that certain categories of people are inherently dangerous and unacceptable: Hispanic people coming to the United States across our southern border, Arab people who are fleeing violence in the Middle East. He is saying, once again, that he will defend American Christians against perceived threats, threats that might be framed in vague religious terms but which are not fundamentally religious. Trump is saying, once again, that he will serve as a backstop against an erosion of power felt by a subset of Americans. He is telling those Americans, white Christian conservatives, that he will make them the focus of America's protective power. The crowd supported this idea enthusiastically. The Republican presidential nominating fight not over. Not one single vote has been cast for the Republican Party's 2024 nominating contest yet, but it's hard to see how the fight isn't already over. Former President Donald Trump holds a huge national polling lead over his opponents, a lead that has little precedent in the last 40-plus years of contested Republican primaries. Perhaps more importantly, though, it's hard to imagine a scenario in which perhaps the best-known non-incumbent candidate for his party's nomination sees a sudden erosion in support large enough to cost him his lead. This question of Trump's lead and its durability was raised by an excellent report from my Washington Post colleagues this weekend, considering how Florida Governor Ron DeSantis's, Republican, once enviable position as the alternative to Trump had collapsed so dramatically that he is now trying to fend off Nikki Haley, the former U.S. ambassador to the United Nations, for second place in national polling. It is no longer the case that Trump and DeSantis are separated from the pack. Instead, an exhausted DeSantis has simply been folded into the chase group. Put another way, Haley is not challenging Trump for the nomination, but, instead, challenging DeSantis for the biggest participation trophy. ABC News's 538 polling analysis site has historic averages of national primary polling that we can compare to Trump's current position. Older Republican nominating contests had spottier polling, meaning that the averages aren't as extensive or volatile. But the comparison is nonetheless instructive. If we use the Iowa caucuses in each contested Republican nominating fight since 1980 as our point of reference, we see that Trump's current national lead was exceeded only once, by George W. Bush in the 2000 primaries. Bush, as you might be aware, went on to easily win his party's nomination. The next biggest lead in the average was held by Bob Dole in 1996. He also won the nomination. Both Dole and Bush also won the Iowa caucuses, which no other eventual Republican nominee has done in a contested primary campaign since 1980. Even Trump lost in Iowa in 2016, barely. He quickly pivoted to accusing the winner, Senator Ted Cruz, Republican, Texas, of cheating. This is important because DeSantis's strategy for winning the election appears to center on victory in Iowa. He shifted campaign staff there earlier this month, with various reports suggesting it will serve as his make-or-break point. His Alamo, perhaps. Should DeSantis eke out a win in the Hawkeye state, though Trump currently leads there by 30 points in 538's average, then what? Are Republicans suddenly going to think that he's a better bet for November and flip their support? It's certainly possible, but DeSantis has been making exactly that argument for months without one polling backing up his arguments or two gaining any ground against the former president. It's useful to remember that Trump's been here before. In 2016, he held the lead in Republican primary polling and went on to lose Iowa before securing the nomination. But his lead that year was never as robust as his lead is this time around. Back then, it was feasible to imagine that something could emerge that derailed his candidacy. In fact, such potential derailments were identified repeatedly, without actually derailing him. Now he's so well known by voters that the idea he might stumble seems much less likely. It's also useful to remember that the perennial "what if all but one Trump alternative drops out" strategy ignores one, that Trump's over 50% in national polling, and two, he's still the second choice for a lot of people who prefer his opponents. Again, no votes have yet been cast. But those arguing that Trump might not win would seem to have a fairly robust burden of proof to overcome. Sure, theoretically he could lose, just as, theoretically, the moon could spontaneously turn purple. If you're arguing that the moon will do that, I'd be interested to hear how. Likewise for the idea that Trump won't be the GOP's 2024 nominee. The Republicans who say we don't even need a speaker. Public polling shows that many on the right don't mind if the speaker fight is protracted, and may even prefer it that way. As Republicans were resisting Representative Jim Jordan's attempt at becoming speaker last week, a talking point emerged among some of his boosters. The House needed to get back to business, stat. It was too important. So just sign on the dotted line, install the Freedom Caucus guy and get it over with, the argument effectively went. We need to get to work for the American people. We need to do what we said we were going to do, Jordan, Republican, Ohio, himself said Friday, adding that we can't open the House until we get a speaker. That argument didn't prove compelling. And not only did Republicans proceed to kill off Jordan's speaker bid, but they then decided it was okay to leave town for a few days, the urgency of the country's business apparently having suddenly subsided and taken a back seat to the desire to go home for the weekend. But even that exercise presupposed something that we probably shouldn't take for granted, that Republicans actually feel a sense of urgency. What if, and bear with us, certain Republicans don't really care whether there is a prolonged period without a speaker and are willing to leverage that for what they want? If even 5 Republicans have internalized that posture, it could prove a hugely significant hurdle, given the winner needs 217 votes and there are only 221 House Republicans. New polling suggests this kind of sentiment is embraced by a significant number of Republican voters. A Suffolk University poll gave people 2 options. Congress needs to elect a speaker as soon as possible to fund immediate needs like support for Israel, Ukraine, and to prevent a government shutdown in November, or I don't care if Congress elects a speaker. Every day that goes by without a speaker means that Congress can't waste more of our tax dollars. Americans chose the former, Speaker Now option by a very wide margin, 67% to 25%. Democrats preferred it 86 to 10. But among Republicans, it's not nearly so overwhelming. Fewer than 6 in 10, 57%, cited the urgent need for a speaker, but 34% chose the latter option. And the lack of urgency is even more pronounced when you drill down a little further. For instance, 40% of people backing Donald Trump in the Republican presidential primary said they don't care when Congress elects a speaker, as did 43% of people who called the pro-Trump outlet Newsmax their most trusted media outlet. This comes with some caveats. One is that these binary choices can push people who aren't passionate toward an option they might not completely agree with. For instance, Republicans who believe the United States shouldn't send aid to Ukraine might be turned off by the Speaker Now option mentioning funding Ukraine as an immediate need. But it's not the only question where Republicans are clearly less insistent upon the government functioning as usual. The same poll shows a majority of Republicans, 55%, prefer standing firm in upcoming negotiations and shutting down the government, if need be, to obtain spending cuts. Just 37% said they would prefer negotiating a compromise to avert a shutdown. Again, the binary choice caveat applies. But all of it speaks to the willingness of a significant number of Republicans to use brinkmanship to get what they want and not caring as much about the potential costs of hamstringing the government in the process. In the case of those who don't feel urgency to elect a speaker now, it's not close to a majority. But one of the unhelpful realities for today's House GOP leadership is that there are a handful of members who are content to cater to a small but substantial and vocal portion of the party. If 4 in 10 Trump supporters tend toward a particular view, there's an audience for it, a constituency to lean on and TV appearances to be booked. At the very least, these members will go right on believing that the potential costs of their ostensibly principled push to gain a like-minded speaker aren't that severe. And after more than a decade of Republicans pushing toward shutdowns and potential debt ceiling breaches, that probably shouldn't be too surprising. Here are the 8 Republican candidates running for House Speaker. After Representative Jim Jordan, Republican, Ohio, failed to become Speaker of the House following 3 votes on the House floor last week, 9 Republicans announced their intention to seek their conference's nomination. 1 has since dropped out, leaving 8 in the running as the GOP conference prepares to gather behind closed doors on Tuesday to vote on its next nominee for Speaker. All Republicans interested in running for House Speaker had to announce their candidacy by noon Sunday to the office of Representative Elise Stefanik, Republican, New York, who chairs the House Republican Conference. Stefanik's office is running the internal meetings in which the GOP lawmakers are expected to choose their next nominee. Democrats, meanwhile, are widely expected to continue nominating and voting for House Minority Leader Hakeem Jeffries, Democrat, New York. All this is happening as Congress inches closer to a key deadline. The government will run out of funds in mid-November and shut down if the House and Senate do not pass a number of appropriations bills. Republicans have virtually frozen activity on the House floor for almost 3 weeks over their inability to choose a new leader. Notably, all 8 GOP lawmakers in the running for Speaker are members of the Conservative Republican Study Committee, one of 5 of the GOP's ideological caucuses and, historically, the largest. 1. Representative Tom Emmer, Minnesota. Representative Tom Emmer, Republican, Minnesota, the House Majority Whip, was among the first to make clear his intention to run for Speaker. Emmer has been in Congress since 2015 and has served as whip since the beginning of this Congress. Before that, he chaired the National Republican Congressional Committee, Republicans' House campaign arm, for 4 years. He is the highest-ranking Republican among the list of official candidates and is a member of the Conservative Republican Study Committee. Emmer, 62, has already received the support of former Speaker Kevin McCarthy, Republican, California. Speaking to Meet the Press on Sunday, McCarthy said Emmer is head and shoulders above all those others who want to run. "We need to get him elected this week and move on," McCarthy said. And, as the Washington Post previously reported, some members of the group who plotted to oust McCarthy have also floated the idea of nominating Emmer for the job. In a statement shared Saturday, Emmer, who supported both Jordan and Representative Steve Scalise, Republican, Louisiana, in their failed efforts to become Speaker, announced his intention to seek the gavel. He highlighted his work as chairman of the National Republican Congressional Committee, which works to elect Republicans to the House, and the connections he's formed with Republican members as Majority Whip. "If given the opportunity to be your Speaker, we will use that same culture of teamwork, communication, and respect to build on the movements that brought us success, learn from our mistakes, and keep fighting for each and every one of you and our Republican majority," he said. But right-wing outlets and allies of former President Donald Trump are urging Republicans not to elect Emmer, who voted to certify the results of the 2020 election for Joe Biden. 2. Representative Kevin Hern, Oklahoma. Representative Kevin Hern, Republican, Oklahoma, who chairs the Conservative Republican Study Committee, told reporters on Friday that he's in the Speaker's race. In a tweet shared later that day, Hern, who supported Jordan's bid as Speaker, said the GOP conference needs a different type of leader who has a proven track record of success, which is why I'm running for Speaker of the House. When McCarthy was initially ousted, Hern was floated as a possible candidate, but he backed out of competing against Jordan and Scalise. Hern, 61, a businessman who owned a number of McDonald's franchises in Oklahoma, has been in Congress since 2018 and has chaired the Republican Study Committee since 2023. He voted to overturn the results of the 2020 election. During McCarthy's speakership fight in January, Hern was nominated as a protest candidate. 3. Representative Pete Sessions, Texas. Representative Pete Sessions, Republican, Texas, who previously chaired the House Rules Committee and the National Republican Congressional Committee, said on Friday that he's running for Speaker. Sessions, 68, who has served 11 terms in the House, highlighted in a Newsmax interview on Friday that he is running because of his years in Republican leadership, and noting that during his time as chair of the NRCC, Republicans won 63 seats in the House. He is a member of the Conservative Republican Study Committee and the Republican Main Street Caucus, which stands at the center of all the ideological caucuses. In a post shared on X on Saturday, Sessions also said that, during his 6-year tenure as Rules Chairman, he helped usher a conservative agenda through Congress. "It's time to get back to work for the American people," he said. Sessions, who supported Jordan's speakership bid, was also one of the House Republicans who voted against the certification of the 2020 election. 4. Representative Austin Scott, GA. Representative Austin Scott, Republican, Georgia, emerged as a surprise speaker candidate last week when he ran against Jordan in a conference-wide vote to select the next speaker designate, after Scalise declined to bring his speakership nomination to a full House vote. Once Jordan clinched the nomination, Scott backed out of the race and supported Jordan in all 3 rounds of voting. When it was clear Jordan would no longer be speaker designate on Friday, Scott announced another bid for the speakership. "If we are going to be the majority, we need to act like the majority, and that means we have to do the right things the right way," Scott said in a post shared on X on Friday. "I supported and voted for Representative Jim Jordan to be the Speaker of the House. Now that he has withdrawn, I am running again to be the Speaker of the House." Scott, 53, a businessman, has served in the House since 2011. He did not object to the certification of the results of the 2020 presidential election and was part of a group of Republicans who, in a letter to congressional leaders, said lawmakers did not have the power to overturn the results of the election. He is also a member of the Conservative Republican Study Committee. 5. Representative Byron Donalds, FLA. Representative Byron Donalds, Republican, Florida, is a relative newcomer to Congress, but, in just 2 terms, he has become a relevant figure in the ultra-conservative House Freedom Caucus. He is also a member of the Conservative Republican Study Committee. Donalds, 44, received several votes from his hard-right colleagues during the January Speaker election, helping slow down McCarthy's path to the gavel. A staunch Trump ally, Donalds voted against the certification of the 2020 election and has repeatedly falsely claimed that Biden is not the legitimate president. Donalds officially announced his bid for the speakership Friday. He told Newsmax that the House is having some issues and that he would unify the conference. "That job can still be done. I believe I am the leader that can get that job done," he said. 6. Representative Jack Bergman, Michigan. Representative Jack Bergman, Republican, Michigan, a retired U.S. Marine Corps Lieutenant General, said Friday that he's running for Speaker because he feels confident he can win the votes where others could not. "I have no special interests to serve. I'm only in this to do what's best for our nation and to steady the ship for the 118th Congress," he said in a statement. Bergman, 76, who chairs the House Armed Services Subcommittee on Intelligence and Special Operations, has served in Congress since 2017 and is a member of the Conservative Republican Study Committee. He objected to the certification of the results of the 2020 election. On X, Bergman noted Friday that he's received the endorsements of Michigan GOP Representatives Lisa C. McClain, John James, John Molinar, and Tim Walberg. Bergman is also supporting a push by Representative Mike Flood, Arnab, to get all Republican lawmakers to sign a pledge to support the ultimate speaker designate on the House floor. 7. Representative Mike Johnson, La. Representative Mike Johnson, Republican, Louisiana, formally announced Saturday that he's in the speaker's race, saying in a statement that he has been humbled to have so many members from across our conference reach out to encourage me to seek the nomination for speaker. "Until yesterday, I had never contacted one person about this, and I have never before aspired to the office," he said. "However, after much prayer and deliberation, I am stepping forward now." Johnson, 51, an attorney and former radio host, has served in the House since 2017 and is the vice chair of the House Republican Conference, serving under Stefanik. From 2019 to 2021, he chaired the Conservative Republican Study Committee. He's also the chair of the House Judiciary Subcommittee on the Constitution and Limited Government. Johnson is a close Trump ally, having served in the former president's legal defense team during his 2 impeachment trials in the Senate. Johnson has also contested the results of the 2020 presidential election. 8. Representative Gary Palmer, ALA. Representative Gary Palmer, Republican, Alabama, was a late addition to the list of speaker candidates. In the House since 2015, Palmer chairs the House Republican Policy Committee. Before joining Congress, he served as president of a conservative think tank in Alabama. He is a member of the Conservative Freedom Caucus and the Republican Study Committee. Palmer, 69, voted against certifying the results of the 2020 election and was also one of over 120 House Republicans who in December 2020 signed an amicus brief in support of a lawsuit that would have invalidated the results of the 2020 election in 4 states. Out, Representative Dan Moiser, PA. Representative Dan Moiser, Republican, Pennsylvania, dropped out of contention Monday. Last week, Moiser, who has served in the House since 2019, said in a post on X that, should he decide to run for Speaker, his message will be focused on politics of inclusion. Every member of the Republican conference needs to be a part of policymaking, legislation, and communications. I believe the show should be about the members and not about the Speaker's office, he said. It's time to get back to work. Moiser, 59, was one of over 120 House Republicans who in December 2020 signed an amicus brief in support of a lawsuit that would have invalidated the results of the 2020 election in 4 states, including his home state. Moiser is a member of 3 out of the 5 GOP ideological caucuses, the Moderate Problem Solvers Caucus, the Main Street Republicans, and the Conservative Republican Study Committee. The layers of falsehoods that led to Jenna Ellis's plea deal. The fundamental failure of Donald Trump's effort to subvert the results of the 2020 presidential election was that it was predicated on complete nonsense. Trump and his attorneys, particularly Rudy Giuliani and Jenna Ellis, seized upon any allegation of fraud or any analysis that presented an opportunity for skepticism about the results and offered them up as valid. Even, in many cases, after it had been made obvious that the claims were not valid. This approach had an obviously useful effect, accomplishing precisely what Trump needed politically. His supporters were subjected to this blizzard of claims, a blizzard that itself was cited as evidence that the election was somehow tainted. That the claims were debunked or irrelevant didn't matter. His supporters treated subsequent claims as more credible in part because they landed in an environment where people were inclined, thanks to that blizzard, to believe that fraud had occurred. Noting that individual snowflakes were fake was often too slow and too limited to make people realize that, in reality, the sun was shining, that Giuliani was just shaking a box of soap flakes above their window. What's important to recognize, though, is that this credulousness almost certainly wasn't limited to rank-and-file Trump voters. It clearly extended in most cases to Trump himself, to Giuliani, and to Ellis. This is not an excuse for their elevating untrue claims, far from it. It is instead meant to make clear the extent to which they created and bolstered a latticework of flimsy, self-referential nonsense that has somehow been sturdy enough to allow the idea that the election was stolen to remain standing even today. On Tuesday, Ellis appeared in a courtroom in Georgia to plead guilty for her role in the effort to subvert the 2020 results in that state. That included an admission that she had aided Giuliani and attorney Ray Smith in knowingly, willfully, and unlawfully making a number of false statements at a Georgia legislative hearing in early December 2020. I relied on others, including lawyers with many more years of experience than I, to provide me with true and reliable information, Ellis said while entering her plea. What I did not do, but should have done, Your Honor, was to make sure that the facts the other lawyers alleged to be true were, in fact, true. In the frenetic pace of attempting to raise challenges to the election in several states, including Georgia, she continued, I failed to do my due diligence. On the day of the Georgia hearing, the New York Times published a lengthy examination of Ellis's thin legal resume. She holds herself out as an expert on the Constitution based on her self-published book and her teaching of pre-law classes to undergraduates, the Times reported. She has never appeared in federal district or circuit court, where most constitutional matters are considered, according to national databases of federal cases, and does not appear to have played a major role in any cases beyond her criminal. This was and is a pattern of Trump's attorneys, in part because more experienced lawyers appear to be wary of representing him. His representation is often less established in the relevant areas of the law. In this case, it wasn't just that Ellis was not as experienced on the Constitution, it was that neither she nor Giuliani had any extensive experience in adjudicating the claims of election manipulation that were being made. Often those claims were being made by relying on complicated, and probably intentionally obfuscatory, analyses of voting records and patterns. In that Georgia hearing on December 3, 2020, for example, Giuliani interviewed a man named Russell Ramsland whom the Washington Post would later identify as a central actor in the fraud conspiracies. But even at the time, his analyses were dubious in content. We're meant to believe that nearly 100,000 votes without any provenance were counted and that this escaped the state's notice, and in practice. He had already been embarrassed when an affidavit he offered purported to show data from Michigan but actually used data from Minnesota. Ramsland would have been an obvious person to whom Ellis should have applied skepticism. It seems she did not. It seems she similarly did not apply skepticism to the second witness Giuliani presented in that hearing, Phil Waldron. Giuliani repeatedly referred to him as Phil Coulson for some reason. Giuliani praised Waldron for having examined a voting machine error in Antrim County, Michigan, which he presented as representative of voting machine manipulation nationally. But that Antrim County error had been explained nearly a month before. It was a mistake made by elections administrators in configuring how votes would be counted. Waldron went on to elevate already debunked claims about Dominion voting systems machines that had been presented by Trump attorney Sidney Powell the prior month. There was no incentive for Ellis to question the claims of Ramsland, Waldron, or any other people making claims about the election, of course. In her plea agreement, she suggested that, as a conduit with the media and elected officials, she was reliant on her colleagues to vet this stuff. But they had no incentive to do so either, beyond the reputational damage they would incur down the line. Even if Giuliani or others had wanted to challenge Ramsland's claims, it's not clear they would have had the technical capacity to do so. After that hearing in Georgia, the Republican-led committee issued a report saying precisely what Trump wanted to hear. Citing the witnesses presented by Giuliani and Ellis at length, it asserted that, he November 3, 2020 election was chaotic and the results cannot be trusted. This, too, was self-serving. Those Republican legislators were probably eager to get Trump's praise and/or avoid his wrath. That report, then, was included in a draft lawsuit sent to Trump and his team in late December 2020. It points to the committee's findings as if they had organically emerged from the committee's independent investigation, rather than representing the committee's own regurgitation of the claims made by Trump's attorneys and allies. That's how all of this got stacked up. Dubious claims from unreliable actors were used to amplify questions about fraud. Those questions were then used to present those and subsequent claims as reliable. Ellis was simply one spigot for the misinformation, one who now claims that she did so unconsciously. In representing Trump, she helped add layers to this house of cards. The core problem, again, was that it was almost all nonsense, that almost none of it was credible. But credibility wasn't the goal, utility was. So lots of useful, false things were offered up, having the effect of making other false things more useful and making those original false things more useful still. Layers upon layers of nonsense. A blizzard in a snow globe held in Donald Trump's hand. 3 years later, people, including Ellis, are starting to pay the price for helping this to happen. Too bad she didn't apply that due diligence, to the extent she could. Jenna Ellis's tearful guilty plea should worry Rudy Giuliani. For the third time in less than a week, a lawyer who worked for Donald Trump has pleaded guilty in the Fulton County, GA, election interference case. Jenna Ellis on Tuesday joined Sidney Powell and Kenneth Casebro in cutting a deal that will require her to testify truthfully about the other defendants, including presumably Trump himself. Her centrality to the case, relative to the others, is debatable. Ellis often served more as a spokesperson than an actual practicing lawyer, though certain actions clearly involved legal strategizing and proximity to Trump. But her plea came with something the others did not, a tearful statement to the court that suggested she is prepared to cast blame up the chain. Whether and how much that includes Trump is a big question. But it would seem to be bad news for Rudy Giuliani and potentially, by extension, for Trump himself. Ellis pleaded guilty to illegally conspiring to overturn the 2020 election loss of Trump in Georgia. Specifically, she admitted to aiding and abetting false statements and writings, a felony that will result in 3 to 5 years probation and other penalties. The deal cited false claims from Giuliani, her frequent traveling companion as they worked to overturn the election results, and a Trump campaign lawyer in Georgia, Ray Smith. Both were indicted alongside Trump, Ellis, and the others. Then Ellis spoke, driving the point home. I relied on others, including lawyers with many more years of experience than I, to provide me with true and reliable information, especially since my role involved speaking to the media and to legislators in various states, she said, adding, "What I did not do, but should have done, Your Honor, was to make sure that the facts the other lawyers alleged to be true were, in fact, true." In the frenetic pace of attempting to raise challenges to the election in several states including Georgia, I failed to do my due diligence. That statement was particularly notable because Ellis elected to deliver it. Before she did so, Fulton County Superior Court Judge Scott McAfee reminded her that she was not required to make a statement in any way. Ellis, like others who pleaded guilty, was required to apologize in writing to the people of Georgia, and she had to acknowledge promoting specific false claims from Giuliani and Smith as part of her deal. But her statement went further than that. One way to read it is that Ellis was trying to salvage her own reputation. By blaming others for the bad information, she was casting herself more as a negligent junior participant than a full-fledged leader of a criminal plot to subvert democracy. Ellis has walked this fine line before. This is the second legal proceeding in which she has admitted to spreading disinformation about the election results, with the first being a March deal she cut to avoid disbarment in Colorado. That deal labeled the false claims misrepresentations, and Ellis soon clarified, lying requires intentionally making a false statement. "I never did that, nor did I stipulate to or admit that." After she cut that deal, she more or less suggested that she had been forced to do so because of legal pressure. "This is and always was political lawfare to intimidate lawyers from representing Trump or Republicans, candidates," she said in a statement. In a criminal case, Ellis will not be able to water down her admission so easily. She is barred from discussing the case publicly. But more than that, she will be required to testify, at which point she will presumably expound upon her claim of having fallen victim to disinformation. A valid question is how much she might blame the others, in other words, whether she will indicate the more senior defendants must have known better or had the kind of nefarious intentions she claims she did not. Giuliani has cast doubt on the idea that Ellis was just along for the ride. He said this summer, "There is no one who was more zealous about the fact that this was a stolen election than Jenna Ellis, and I think that anyone on that team would testify to that." It is also possible that the Trump legal team could cite Ellis saying she did not know better to argue that Trump fell victim to bad lawyering. But when it comes to defendants put in the spotlight by her plea, one stands out: Giuliani. Ellis traveled the country with Giuliani after the 2020 election, speaking to legislators in hopes of getting states to overturn their results. She also participated in other meetings and phone calls with Giuliani and key state figures, as well as the infamous November 19, 2020, news conference with Giuliani and Powell. In the 91-page indictment, she is mentioned in 12 of the 161 overt acts in the alleged racketeering conspiracy, the count for which she did not plead guilty. In 10 of those 12 overt acts, she is mentioned alongside Giuliani. The only instances in which Ellis is mentioned without Giuliani are a pair of memos she allegedly wrote ahead of January 6, 2021, strategizing how Vice President Mike Pence could participate in overturning the results in Congress that day. Those memos, like others written by another Trump lawyer, John Eastman, will figure in the case ahead. But it has become evident in recent days that the case of Fulton County District Attorney Fani Willis, Democrat, relies heavily, for now, on flipping people up the chain of command. In addition to the 3 lawyers, another defendant has previously pleaded guilty, bringing the total to 4 of 19 defendants. And the plea by Ellis is particularly ominous for the Trump team, even aside from her close work with Giuliani. For one, she has in recent months criticized Trump and largely aligned herself with the campaign of Florida Governor Ron DeSantis, Republican. The second reason is timing. The pleas by Powell and Casebro made sense, given they were slated to face trial this week. But Ellis was not so obviously under the gun, as she did not request a speedy trial. She cut a deal anyway, and then elected to publicly and vocally point the finger at others whom Willis is prosecuting and could also try to flip as she pursues a conspiracy case, with Trump at the very top. There is no evidence yet that Ellis has gone full Michael Cohen, the first of the Trump lawyers to plead guilty and who, as it happens, testified against Trump in his New York civil fraud trial on Tuesday. But it is never a good sign when your own lawyer flips and then goes above and beyond to gesture at those above her. Georgia's 6-week abortion ban stays, for now, state Supreme Court rules. Georgia's 6-week abortion ban will remain in place after the state Supreme Court ruled Tuesday that the law is valid, a move that leaves abortion largely inaccessible in the South. Tuesday's ruling reverses a lower court decision from 2022 that struck down the law on the grounds that it was unconstitutional when the state legislature passed it in 2019. At the time, Roe v. Wade, which barred states from prohibiting abortion before viability, was still the law of the land. Doctors, abortion providers, and other advocacy groups argued that the law was not only unenforceable because it was void ab initio, void from the start, but that it violates due process, equal protection, and other rights inherent in Georgia's constitution. Fulton County Superior Court Judge Robert McBurney agreed with the plaintiff's argument about the law's timing. He determined in his 2022 decision that key parts of it were plainly unconstitutional when drafted, voted upon, and enacted. The majority in Georgia Supreme Court, however, disagreed. The holdings of United States Supreme Court cases interpreting the United States Constitution that have since been overruled cannot establish that a law was unconstitutional when enacted and therefore cannot render a law void ab initio, Justice Verda M. Colden wrote for the majority. The law was among the strictest in the nation when it was signed by Governor Brian Kemp, Republican, in 2019. The case will return to the lower court to settle the questions over whether the violates inherent rights in the state constitution. While Tuesday's decision is not the final word on the state law, it was hailed by Kemp and his Republican Attorney General, Chris Carr, who said his office will continue to defend the constitutionality of the law, known as the Georgia Life Act. Carol McDonald, President and CEO of Planned Parenthood Southeast Advocates, said in a statement that its health care centers in the region will remain open to provide the limited abortion care that is legal. The current law bans abortion after 6 weeks, which is the earliest that fetal cardiac electrical activity, distinct from the heartbeat of a fully formed organ, can be detected. The law has few exceptions, which include when the pregnant person's life is at risk or in cases of rape and incest, with the requirement that a police report is filed. Monica Simpson, Executive Director of Sister Song Women of Color Reproductive Justice Collective, the lead plaintiff in the case, called the Tuesday decision devastating. This abortion ban has forced Georgians to travel across state lines at great expense or continue the life-altering consequences of pregnancy and childbirth against their wills, she said. The fight over abortion access has only intensified since the U.S. Supreme Court's Dobbs v. Jackson Women's Health Organization ruling last year made control over abortion laws a state issue. Abortion is now banned or heavily restricted in 18 states, including Georgia, according to the Guttmacher Institute, a nonprofit research center that supports abortion rights. Among these, 15 instated total bans, with very limited exceptions. 2 others ban abortions at 12 weeks and onward. SBA Pro-Life America President Marjorie Dannenfelser framed Tuesday's ruling as a win for anti-abortion advocates, saying in a statement, "When you lead and stand boldly for life, Americans will stand with you." But the reality has been different at the ballot box, where voter referendums to preserve or expand access to abortion have been successful as well as galvanizing forces for abortion rights advocates. Today's ruling is not the end of this fight for women's health care, Andrea Young, Executive Director for the ACLU of Georgia, said in a statement. "Be clear, the right to abortion is on the ballot in 2024. Governor Brian Kemp and the Georgia legislature acted to take away our rights. The Georgia legislature can restore our rights and we must organize to elect a pro-choice legislature." Karine Jean-Pierre, a spokeswoman for President Biden, decried the ruling. She said in a Tuesday statement that the administration won't stop fighting until the protections of Roe v. Wade are restored in federal law. The state of abortion access has been under continual revision since it passed in 2019. Though it was on the books, a federal court blocked the law from taking. The ban was allowed to take effect in June 2022, when the U.S. Supreme Court overturned Roe's decades-old protections. Then the law was overturned in November of that year in Fulton County, only for the Georgia Supreme Court to grant an emergency stay of the injunction a week later, which allowed the legislation to remain in effect while appeals continued.